So I'll use the organization that's a pretty popular one, but still it might be a good idea to listen casually to all of these tapes, just to get a general idea of what this is all about. And then go back and listen more carefully to the section that corresponds to whatever you happen to be studying at the moment. We're going to talk about bases of liability with the corresponding affirmative defenses. We're going to talk about proximate cause and damages, and once we've covered those basics, we're going to cover some particular areas of tort liability, families of torts that you'll be studying in your torts course. So that's what our organization is going to be, and we're going to start with fault. We're going to start with bases of liability, and first we're going to look at fault. And the very first one we look at is going to be intent. Now, usually, what happens in law school torts classes is that as part of the general study of each basis of liability, you look at a few specific torts that are built around it. So that's the way we're going to approach it. We're going to look at the law of intent. We're going to say a few things about intent in general, and then we're going to examine 7 of the intentional torts. There are many more torts that involve intent, but we're going to be looking at 7 of them to get a general idea, a better understanding of what the law of intent is all about. And of course, we have to start with a definition. Now, the definition of intent is really going to vary from one tort to the next. Each of the intentional torts will have its own special definition for intent. But in general, we say that intent in the law of torts means that the defendant desired or was substantially certain that a specified result would occur. And we're going to have to specify what that result is. And each one of them is going to be different depending on which of the torts we're talking about. For example, and don't worry about learning this now, we're going to cover it in more detail later on. For example, in a false imprisonment case, intent means the desire or substantial certainty that the plaintiff would be confined. On the other hand, in a trespass to chattel case, intent is the desire or substantial certainty that the thing involved would be affected by the defendant's conduct. Each tort will have a different definition for intent, but remember that in all the intentional torts, intent is a state of mind. It's a subjective state of mind. It's something that must actually have been going on in the defendant's head. It doesn't matter what the reasonable person would have desired. It doesn't matter what the reasonable or ordinary person would have been substantially certain of. What really matters when we talk about intent is what the defendant was thinking. Now, of course, that raises a problem. You can never really know what somebody is thinking, except when you take an exam. Because when you take an exam, very often the facts tell you what a particular person was thinking. And then you can decide, when you look at what that person was thinking, whether that constituted intent. But when you're not taking an exam, when you're living in real life and you have to try to figure out what somebody was thinking, all you can do is look at their behavior and say, well, usually when somebody acts that way, they must be thinking so-and-so. What we're talking about now is the difference between a subjective state of mind, that's what's going on in a person's head, and objective evidence of it. So, you may not know what's going on in my mind, but if I point the gun at you and say, I'm going to kill you, and then I pull the trigger and a bullet comes out and hits you, you can probably figure that I was thinking that I desired to hit you with that bullet, because ordinarily when a person acts the way I acted, that's what such a person is thinking. So don't be confused about the difference between objective evidence and a subjective state of mind. Okay, we're still talking generally about what intent means. Then we're going to look at some intentional torts. And so it's real important for us to know the difference between volition or voluntariness and intent. And that's something that confuses a lot of people. Volition means the desire to perform a particular act, the desire to use the muscles in a particular way. Intent means the desire or knowledge, substantial certainty, that a particular result will come about because of that act. So, for example, if I'm holding a pistol in my hand and I don't mean to pull the trigger, but suddenly I cough and the cough causes a spasm and the spasm makes my finger tighten on the trigger, Well, I didn't pull that trigger voluntarily. I didn't have volition. And if you don't have volition, you can't have intent. But suppose that I do voluntarily pull the trigger while the gun is pointed in your direction. However, I believe that the gun is empty. If I believe that the gun is empty, I could not have had a desire or substantial certainty that I would be hitting you with the bullet. And even though my act was voluntary or volitional, I did not have the intent necessary to make me liable for certain intentional torts, and we'll talk about that when we come to them. So that's the difference between volition and intent. Remember, there can never be intent without volition, but volition is not enough to constitute intent. It's also important to know the difference between intent and motive, because intent is my desire or knowledge that a certain consequence will result from my behavior. Motive is my reason for wanting to bring that consequence about. And the law of intentional tort is not usually concerned with motive. We might see a few situations later on, like on the fourth tape, in which the law of torts concerns itself with motive, but most of the time it does not. So, if I desire to shoot you with a bullet because I think that'll be just a fine joke, and when you're hit by the bullet, you and I are just going to have a wonderful laugh about it. All the time that you're in the hospital, we'll be laughing about it because we're great buddies and I'm going to play a great joke on you. My motive might have been healthy, although it sounds a little twisted, doesn't it? But my motive might have been healthy, to play a joke. The law of torts doesn't care about that. What matters is that I desired to hit you with a bullet, or I intended to hit you with a bullet. And that will probably be enough to result in liability for certain intentional torts. And if you understand that, then you'll understand those cases that you're going to read or that you've already read that say that an insane person or an infant, that is a child, can be liable for intentional tort. Why? Because we're not really concerned with the mental health or the mental maturity of the defendant when we talk about the intentional torts. We're concerned only with the defendant's subjective state of mind. Now, there may be a time when a 3-year-old child holding a pistol in her hand and pointing it at me doesn't know that pulling the trigger will make a bullet come out and hit me. And if that's so, well, that child isn't going to be liable to me for intentional tort, but not because she was a child. She's not going to be liable because she didn't have the necessary intent. On the other hand, a young child who points a pistol at me and pulls the trigger may know very well that a bullet is going to come out and strike me. And if the child knows, to a substantial degree of certainty, that that bullet is going to strike me, or that when he pulls a chair out from under me, I'm going to fall down and strike the ground, sustaining an injury, you're probably going to read that case, Garrett against Daly. If the child knows to a substantial degree of certainty that his or her conduct is going to result in some injury to me, then the child intended that injury to me and can be liable for the intentional tort without regard to the question of how old he or she was. The same is true about an insane person. You know, the medical community would never use the word insane. It's a legal word, and it refers to somebody who lacks mental capacity. And you'll probably spend a lot of time in another course finding out what that means. But there may be a person who, because of his or her insanity, thinks he or she is the only person in the whole universe and is waving his arms in the air or her arms in the air to try to maintain universal stability. I'm walking by, but this person doesn't even know I'm there because she believes herself to be the only person in the universe. So when she swings her arms and happens to strike me with her arm, she's probably not going to be liable to me for an intentional tort. Not because she was insane, but because she didn't intend the harm to me. On the other hand, there may be an insane person who knows very well what's going to happen when I walk into the room and she lifts a table leg in the air and says, if you come into this room, I'm going to bash your head in with this table leg. And then I walk into the room and sure enough, she bashes my head in with the table leg. Isn't that case of McGuire against Almy that appears in so many torts books? She's liable to me for some tort, probably battery. Why is she liable to me? Well, we don't care about the fact that for some purposes, maybe for the purpose of making a will, we would call her insane. What matters is that she desired or knew to a substantial degree of certainty that her act would result in bashing my head in. So she intended to bash my head in, and will hold her liable for that intentional tort.